You're watching the legal breakdown. So, Glenn, we have some news here in Donald Trump's Washington, D.C. trial. Judge Chutkan has denied his latest effort. Can you explain what happened here?
Yeah, Donald Trump's defense attorneys asked Judge Chutkan for permission to issue 7 trial subpoenas because they're on what I would call a snipe hunt. They are claiming that there are all sorts of missing materials from the January 6th House Select Committee investigation, even though there's really no evidence that there are missing materials. And so they wanted Judge Chutkan to authorize them to subpoena 7 individuals, including a number of representatives, to come in and testify about this sort of allegedly missing material. And Judge Chutkan sort of saw it for the fishing expedition it is, and she denied all 7 subpoenas.
Okay, now she did call this a fishing expedition. What did she believe that Trump was intending to do with this information?
I think she believed that Donald Trump was trying to throw sand in the gears, which frankly is what he and his attorneys are always trying to do. One thing that they try to do is create issues that they think they can appeal in hopes that the appeal might delay the trial date, which is currently set for March 4. And I think if you want a really direct understanding of how Judge Chutkan viewed this request for these 7 subpoenas, in their determination to find the missing House Select Committee materials, here are 2 sentences that give us a pretty clear view of exactly what Judge Chutkan thought of Trump and his lawyers' claims. She said, "The broad scope of the records the defendant, Donald Trump, seeks, and his vague description of their potential relevance resemble less a good faith effort to obtain identified evidence than they do a general fishing expedition." And then she goes after them even a little bit harder in this next sentence. She says, "If the moving party," means Trump, the party seeking the subpoenas, "if the moving party cannot reasonably specify the information contained or believed to be contained in the documents sought, but merely hopes that something useful will turn up, this is a sure sign that the subpoena is being misused." Those are pretty strong words coming from a judge, that the defense attorneys are trying to misuse the subpoena power. So Judge Chutkan was having none of it.
When it becomes clear, like it is right now, that Donald Trump and his team are filing frivolous motion after frivolous motion after frivolous motion, all of which are being denied, does he risk a ban on these motions, or do these processes just have to play out every time and we, just have to hope that Judge Chutkan swats them down quickly so that they don't lend him the delay that he's seeking?
It's a great question, because it seems like at some point the judge should invoke the doctrine of enough is enough and just cut this nonsense off. But I'll tell you, here's my experience as a former career prosecutor. When it comes to criminal trials, as opposed to civil trials where judges are far more comfortable and willing to shut this kind of nonsense down, when it comes to criminal trials, the ultimate goal of the prosecutors is generally depriving somebody of their liberty. That is a very weighty issue. So ordinarily, judges will allow defense attorneys to make what turned out to be frivolous motion after frivolous motion after frivolous motion. And rather than prohibiting them from filing any more motions, the judge will just kind of saw the wood in front of them, will reject the motion, and then we'll move on to the next frivolous motion. I don't know that I've ever seen a judge in the context of a criminal trial say, you've filed so many frivolous motions that I am prohibiting you from filing any additional motions, because something may develop during the run-up to the trial or during the trial itself that would result in a potentially meritorious motion being available to the defense. So I think Judge Chutkan and her staff and the prosecutors and we the people will just have to endure all of these frivolous motions by Trump and his lawyers until we can get this case into trial beginning on March 4th.
Well, even though Judge Chutkan has been pretty efficient in terms of swatting down all of these frivolous motions from the Trump team, were these delays already built into the schedule, or is this taking extra time than what we had initially planned for?
Yeah, so Judge Chutkan set a briefing schedule, and she anticipated that Lots of motions would be filed. So this is all part of the ordinary run up to a trial. Lots of motions get litigated. Now, in my experience, the motions that get litigated tend to have some merit to them. But I don't think this is delaying the eventual start date of the trial. It's probably making a lot of really annoying busy work for a lot of people. But, this is all part of the run up to trial. It's just that when it comes to Trump and his lawyers, you're going to see a whole lot of nonsense being thrown at the court, kind of like just throwing it all against the wall and hoping that something may stick.
Okay, so these frivolous motions aren't going to push back the start date for this trial, but as of now, is there any reason to believe that this trial wouldn't start on time, which would be March of 2024?
We're not out of the woods yet because there are two motions that have been filed, and these are different than lots of the other motions that get filed in the run up to a trial, because these two motions, if meritorious, which they're not, that's the good news, but if they had merit to them, they would be case ending motions. One is a double jeopardy motion that's been filed by Donald Trump, and the other is an absolute immunity motion that's been filed by Trump. Now, people should know, ordinarily, you can't appeal anything in a criminal case until the conclusion of the trial. That is, after the defendant has been convicted and sentenced. That's when a defendant's appellate rights come into existence, and the defense attorneys on appeal will package up everything they thought was a legal error during the course of the trial, and they will appeal it all at once. But there's an exception. The exception is if there are potentially case-ending motions, then those motions can be appealed immediately if the trial court judge denies those motions. So if there is a viable double jeopardy motion and it's successful, it's a winning motion for the defense. Let me say it again, Donald Trump's is not. But if it is, then the case is over. The indictment gets dismissed and there is no trial. The same is true for an absolute immunity motion. If it's successful, and Donald Trump's is not, it would end the case instantly. Why? Well, because if somebody had absolute immunity, they couldn't be made to sit through a trial and a sentencing hearing and then get to assert their right to absolute immunity. So because these two motions are potentially case ending, Donald Trump can appeal them immediately. So that's the only possibility that this March 4 trial date would get delayed, would get pushed down the road. If one or both of these motions catch the interest, pique the interest of the Supreme Court, then they could, in theory, take that issue, that motion on review, and they could put a stop. They could pause or stay the trial proceeding until they resolve that issue or those issues. I don't think that's going to happen because both of these issues are not just meritless, they're frivolous, they're laughable, but Donald Trump has made them and the courts have to deal with them.
Yeah, and I'm sure that Clarence Thomas would love nothing more than the opportunity to meddle in this case on Donald Trump's behalf. Glenn, let's finish off with this. Can you talk about the timeline? Assuming that this trial does start on time, what can we expect in terms of the rough end date to this trial, the verdict, and then the actual sentence itself?
Yeah, we've seen some reporting that the parties, the prosecutors, the defense, estimate the trial could take maybe 4 to 6 weeks. Now, that is all art and no science. Nobody ever knows precisely how long a trial will take. But if we use the 4 to 6 weeks as a guide, we could see a jury verdict sometime in late April or maybe early May. And then from the moment that a jury returns a verdict, assuming the verdict is guilty, then there has to be what's called a pre-sentence report generated. That takes some time. That's a report that's put together and given to the judge to help guide the judge's sentencing decision. So ordinarily from the date of the guilty verdict, there will be a 60 to 90 day break before you have the sentencing hearing. And then on the day of the sentencing hearing, the judge will announce her sentence. That's not the kind of thing that people take under advisement. The sentence is handed down right at the end of the sentencing hearing. So Donald Trump could find himself convicted by, perhaps sometime early fall.
Okay. And obviously, we'll stay on top of any changes as they continue to come in. And if there are any delays, God forbid, in this trial, then we'll stay on top of them as well. So if those of you watching right now want to stay on top of this trial, please make sure to subscribe. The links are right here on this screen. I'm Brian Taylor Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.